Thank you, Mr. Chairman and members. My name is Brian Sledge. I'm an attorney representing the Barton Springs Edwards Aquifer Conservation District. And in testifying in support of Senate Bill 1440. You've heard a lot of testimony here today that is simply incorrect and designed to conflate the issues and put up a smokescreen. All that's happening here is an area has been identified that, looking on the Water Development Board map, as the Hays County Commissioner testified, of groundwater districts would indicate that it's covered by a groundwater district. But the Edwards Aquifer Authority covers this piece of property in Hays County, but they only have regulatory authority over the top layer of the earth there, the Edwards Aquifer. And this is drilling through that to the underlying areas. I don't know what bill the City of Buda has been looking at, but there's nothing in here that interferes with anybody's contract. There's nothing in here that treats them differently than anybody else. All that is in here is an expansion of this district's territory to include this piece of Hays County. While this Electro Purification issue and all the media attention it got might have led to this, it's no different than any groundwater district we've ever created or expanded in this state. There's always existing projects, there's always existing municipal wells, and there's always the application of those rules fairly and equally to those wells, just like there are in any other groundwater conservation district. This lawsuit that's been filed, which I would couch to you as a long shot lawsuit, did claim that this territory was in the other groundwater district, but it doesn't matter whether it claims that or not. It's probably not. It's a long shot, and regardless, Senate Bill 1440 will specifically clarify the jurisdiction of the Edwards Aquifer Authority, the Barton Springs District, and the Plum Creek Water District over the water resources in Hays County to make sure that we don't have overlapping jurisdiction on any resource, but that all resources are protected. Appreciate working with Senator Campbell's staff and Senator Zaffarini's staff and Senator Watson's staff on the City of Austin issue. We've reached an agreement with them and are working on some language, and I'd be happy to answer any questions you have on this topic.
So your testimony is regardless of the district lack thereof, after the bill's filed, the jurisdiction through the various would clarify that?
Jurisdiction by surface area and by layer of the aquifer.
So can you answer it this way? I understand DFCs and whatever the management tools groundwater might have. If you expand or incorporate, if you will, a non-district area into a district that has contracts, and you may not know this answer, but this is the area of the law that this is where we're going.
Yes, sir.
We've got things coming up over the next year, but so if I have a situation such as this where there's a contract with a requirement from an entity that has contracted with the private landowner to be able to service that, and a district takes that over and they determine what is the status, I guess, of that pool, would they automatically come under the DFCs or whatever management tools that water district have, or would there be a provision to allow for that process? I mean, is this new law, or is this something that's existed in your experience?
It's something that's existed forever.
What happens in that situation?
As I said, one of the things that I've witnessed in my 20 years of doing this is that nobody ever creates a groundwater district or ever expands the territory of one until you have a problem. Mm-hmm. And here we have a problem. Here's an area where the TCEQ has said, we've got critical groundwater problems. High growth corridor, very few groundwater resources, we need a district here. And the options are limited. Every time you take that over, you've got tons of different water supply contracts that are going to be impacted, municipal wells, industrial wells, power plant wells, irrigation wells, which are equally important to the farmers. And the districts have to be careful in how they step when they do those things, and they have to treat folks fairly and equitably as required by Chapter 36, but they're always impacting folks that already exist, and this is no different. The fact that somebody could argue that, well, if I put a contract on my water instead of just drilling my own well, I can somehow escape management by the state, who wouldn't do that then? So we have no axe to grind with this project, and we expect, if the district's boundaries are expanded, to have probably a very well-attended permit hearing when this permit application comes up to the board. But my board's committed to treating these folks fairly and equitably under the rules of the district and the law that this legislature provides to us.
So I may be confused. Is the status of the project, is that they're well drilled and in the ground today? Does the City of Buda have a well?
You may want to ask EP on that. Okay. You're talking about the EP wells?
Yeah, I just thought there was already water being pulled out of that.
I think they have a test well.
Test wells.
Okay, all right.
For a number of them, yes.
Okay. So, from that perspective, the water district would truly still have control of the permitting process.
Yes, sir.
If their wells were in, would that change?
It would not. I mean, when districts get set up, and as general counsel to a lot of districts, my counsel is this: if you adopt spacing regulations for well spacing, you cannot apply those retroactively to wells that have already been drilled, because they're drilled where they were at the time under the rules and the law when they were drilled. But other types of production regulations based on impacts to other users, impacts to the groundwater resources, are the same types of things that you can apply equitably across the board.
You need to state your name.
My name is Katarina Gonzalez. I'm an assistant city attorney for the City of Buda. One of our issues with having a regulatory scheme imposed, 4 to 5 years after this project has begun, is the delay that it will cause for the project. In conversations with the district, we do not believe that it can get permitted in time for Buda to have water by 2017 when they need the water.
Can you address that?
And one of the things, we had met with Electro Purification, who's providing the water, and one of the things that I suggested to their attorney, this is an interesting and high-profile situation. If we wanted to put some transition language in there to have expedited processing of a permit application, for bracketed however you want, a contract with a city to supply water, we could do that. They're still going to have to drill the wells. That takes time. There's still the rights of the other property owners around them to be heard in what I presume will be a contested case hearing. That takes time, but we can process it as quickly as we can under the law. I would counsel anybody that asked me, if somebody comes to you drilling a well in one of the major or minor mapped aquifers of this state that's currently not subject to groundwater district regulation, to be very wary that it could soon be subject to groundwater regulation, because virtually all of it is in this state. There's just a few little spots left. This is one of them, and this is something that's likely to happen in those situations.